state court judgments. But be careful here. The Supreme Court doesn't have general review authority over state court judgments. They only have review authority over state court judgments involving matters of federal law. The case has to involve a matter of federal law. And in terms of that, if you do have a federal issue in the case, that's a basic prerequisite to get the Supreme Court to look at that case. But even though that's absolutely necessary, even that is not sufficient to get the Supreme Court to look at a case coming from the state court system. There are other requirements that also must be followed. First, the state case must involve a final judgment, not just an interim or interlocutory ruling. It has to be a final judgment from the state courts. In addition, the judgment also has to be from the highest state court from which a judgment could have been had. Now, this doesn't have to be the state Supreme Court or its equivalent, but it has to be the highest state tribunal from which a judgment could have been had. In some kind of cases, let's say you're charged with spitting on the sidewalk, and you want to say that that law violates the Constitution, the federal Constitution. But the highest state court that will review that kind of low-level infraction is the county court. Well, that's the highest state court from which review could have been had, and if you seek that and you go as high as you can, that's enough. You simply have to exhaust your state court remedies first. And finally, even if you have a federal issue to be reviewed, and even if you have a final judgment from the highest state court from which review could have been had, there's still one more requirement. It has to be the case that there is no independent and adequate state ground on which the state court decision below is based. Now, what does that mean? Well, imagine that you're suing in state court, this is our assumption, and that you're raising two kinds of claims. Let's say you're claiming that a certain railroad tax was not authorized by the applicable state statute. And you're also saying that the tax violates the federal Constitution, let's say the Commerce Clause. And let's further say that you go all the way up as high as you can go, and you get a final judgment from the state courts on this case that you've brought, and now you want the Supreme Court to review it. Well, the Supreme Court won't review this case if the decision is based on state law, such that no matter what the Supreme Court decided about the federal question, the case would still come out the same way on the state law ruling. Assume, for example, that the state Supreme Court held that the railroad tax was not authorized by state statute. Even if the state court went on to say that what the Commerce Clause required, the Supreme Court would not decide that case, because no matter what the Supreme Court said about the Commerce Clause, the state judgment that the railroad tax violated state law would still be determinative of the outcome in the case. Another example. Let's say you had a state court rule that an anti-litter law violated the state's Constitution and also the First Amendment of the federal Constitution. Again, the Supreme Court won't review a case like that on appeal, even though there's a federal issue involved, because no matter what the Supreme Court said about the federal First Amendment issue, the law would still be invalid under the state court's interpretation of its state law. Now, the rationale for this independent and adequate state ground bar is really twofold. One, as a practical matter, sort of common sense, is that it would be a complete waste of time for the Supreme Court to review a case where, no matter what it said, the outcome would still be the same under state law. And second, more technically, it would actually be an advisory opinion by the Supreme Court, because nothing would turn on what the Supreme Court decided. Now, there are exceptions to this independent and adequate state ground bar. First, if a state mixes up the federal and state ground of its decision so that it's unclear whether the outcome actually rests on state or federal law, then the federal courts, the Supreme Court, can review it. Another exception is if the state says that it's relying on state law, but state law is actually interpreted as incorporating a federal standard, then that too will provide review authority to the Supreme Court. Finally, there are some kinds of cases where the state improperly, in bad faith, really just tries to foreclose Supreme Court review by deciding a case on a phony state law ground, perhaps a procedural rule that otherwise wouldn't apply. For example, let's say you have a criminal case and the state courts say that the criminal defendant failed to comply with some state procedural rule and therefore is barred under state law from raising a particular claim. But it turns out that the rule was one that was rarely applied or was actually quite silly, for example, about whether you used the wrong size paper, and maybe it's the case that the state had never enforced this rule in other cases. If you find evidence like that, even though it looks like you have an independent and adequate state ground bar to Supreme Court review, the Supreme Court will look past that in order to get around what is actually a bad faith attempt to prevent the federal courts from looking at a federal issue. So, if you're asked about Supreme Court appellate review authority over state court judgments to review, the absolutely essential ingredient is that there is a federal issue involved in the case. But in addition, in order to get that review, it has to be that the state court judgment was final, that it came from the highest state court from which review could have been had, and that a state court, that is a Supreme Court ruling on the federal issue, could in fact change the outcome of the case. That is, the decision did not rest on an independent and adequate state ground.